Item number 1.
Yes.
My lord, this matter, in fact, the connected issue is still pending in the Honorable Apex Court. So may I pray, my lord, that we will visit after 3 weeks, 3 or 4 weeks, subject to lordship convenience.
Amit, this is your lordship. Your lordship, the matter before the Honorable Supreme Court will come tentatively, your lordship, on 19/3/25, 19/3. So let it come after that, your lordship.
Adjourned till 9th April.
Lordship, highly oblige, your lordship.
Same order.
Item number 2.
Service completed.
Service complete, my lord.
Yes, Your Lordship, I'm appearing for the respondent.
What is the delay?
A delay of 124 days.
Your Lordship, I would like to file a small objection to the condonation of delay application.
Go ahead. $124 days delay you will oppose.
Your Lordship, because we have written several communications to the appellant authorities, Your Lordship, and all the replies were the same.
On the prayer of learned advocate for the respondent, let affidavits be exchanged in the section 5 application according to the following direction: affidavit in opposition by 10th March, affidavit in reply by 20th March, full stop. Next line lists the section 5 application on 24th March. Paragraph. During pendency of this application, the respondent shall not take any steps to enforce the impugned judgment and order or take steps in contempt.
Your Lordship, there is also a caveat application, but apparently the appellant did not serve as a copy. Caveat application was also there, Your Lordship.
If copy is not served, take no note of it.
My Lordship.
When copy is served, they will
Yes,
do it.
caveat expired also, my lord. Caveat's validity is 90 days.
6 months, sir. It was not expired yet.
Okay.
Highly obliged, Lordship.
Item number 3.
Yes, please.
My lords, this is the reports are before my lords in this district judge's report, my lord.
Sorry,
District judge's reports are before my lords.
what is the matter about?
This matter is about, my lord, there are two issues where the Supreme Court had directed or requested to find out whether the compensation amount, there was an excess payment of compensation amount. This is regarding the land acquisition pertaining to the expansion of the Omroi Airport, my lord. So, to start with, my lord,
It pleases your lordships. Lordships, I'm appearing on behalf of the respondent number 3. Since the conducting counsel is indisposed for the day, may kindly the matter be adjourned for the day, your lordships.
1 minute. This matter has not been heard before.
my lord, not by this bench, my lord.
Any order passed?
May I give the background of this case, my lord?
Let us see the previous orders.
If my lord pleases, my lord may see from 21st February 2023 order onwards, my lord.
Who is respondent number 3?
Appearing on behalf of the respondent number 3.
Huh?
Claimant number 2, respondent number 3.
Sorry?
I'm appearing on behalf of the respondent number 3. Claimant
Who
number
is respondent number 3?
Patricia Lingdor.
Patricia Nongsich. Patricia Nongsich is the lady who said she bought a land from the claimant number 1 and who offered the land to the government for acquisition. So basically, most of the allegation it's against Patricia Nongsich, my lord, the claimant number 2, represented by my
No,
friend.
the inquiry is whether excess compensation has been paid for acquisition of land.
Yes, my lord. The finding.
District judge has filed his report.
Yes. She has filed the report. The reports are before my lords, and there's a finding that indeed there was an exorbitant amount of amount has been paid, my lord. Then the amount that was offered, and then more than the amount that she has bought.
But who is the petitioner?
No, this is a suo motu case, my lord. This is a suo motu case. What happened, my lord? There is one order. If I will read this order, my lord, everything will be clear, my lord. This is a 2nd August 2017 order. What happened, my lord, initially when the full bench of this honorable court, my lord, directed to complete the construction of the expansion of the Umroi airport within a period of 4 months, my lord, because all the obstructions that was coming on the way of the expansion has been removed. So the full bench of this court passes an order for completion of the expansion within a period of 4 months. Now, some individual, my lord, they approach the Honorable Supreme Court, saying that they claiming themselves to be the tenants of the land that was supposed to be acquired, my lord. So they're saying that we have not got our tenancy interest. But and before the Honorable Supreme Court, certain issues crop up, where the allegation of excess amount of payment was made, my lord, then what was offered. And there was also a disputed question of fact that there's some saying that the claimant number 1 is saying, I have not sold my property, the sale deed was forged. All these kind of issues crop up before the Honorable Supreme Court. So the Honorable Supreme Court on 2nd August 2017 says that at no cost the expansion of Umroi airport should stop because it is a public interest. But however, with regard to the other issues, that whether who is entitled to compensation or whether the public money has been squandered by offering.
No, but what is the interest of the respondent number 3?
The respondent number 3, my lord.
Just clarify, my lord. Here, claimant number 2 or the claimant number 1, my lord, before the inquiry officer, Stitikar is the landowner, my party. Now, the pursuant to this on court direction, land acquisition proceeding was started, and the claimant number 3, using the sale deeds, offer 32 acres of land to the collector. That please, this is my land, you can acquire it. So acquisition was done. Offer was made to her, 32 crores was released in her favor, claimant number 3. She withdrew the compensation. Thereafter, my lord, the original landowner comes to know this, so they file.
Respondent number 3 was the tenant.
But he purchased a so-called purchaser of my 10 acres, not 32. Now the
Purchaser from your tenant.
from my tenant, from the original landowner. Now I'm the original landowner. I have a tenants in the place. Now without informing the original landowner and the tenants, now the claimant number 3 offered the plot to the collector. Collector has acquired it. Compensation was paid to him, to the claimant number 3. Now matter went to Supreme Court, and Supreme Court has referred to matter.
You are the owner of the land.
I'm the owner of the land. Now what happened to Supreme Court? Supreme Court has framed 2 issues.
There's only one parcel of land which is being acquired.
Yes, one parcel of land.
32
one
acres.
parcel of land.
And you are the owner of the entire.
Yes, that is my claim, madam. Now
No other owner.
no other owner. No, the claimant number 3 is now claiming that she has purchased. Now, in view of that, my lord, Supreme Court has framed 2 issues.
Purchased from whom?
From me, from the original landowner. They also admitted that they purchased from me. Now, therefore,
When?
my lord, in the year 2010, 11, my lord. Now, because of 2017, Supreme Court has framed 2 issues as to whether the Chief Justice of this Honorable Court was directed to nominate a district judge to conduct inquiry to find out 2 issues as to whether the compensation amount awarded to the claimant number 3 is exorbitant or not. Number 2 is who is entitled for compensation, whether the original landowner, claimant number 3, or anyone else. So to find out this, my lord, inquiry was conducted. Inquiry report was placed initially, first inquiry report. That inquiry report did not capture the entire issue. Therefore, this Honorable Court, my lord, directed again for fresh inquiry. Fresh inquiry was conducted in the last October 2023. Inquiry was submitted.
You sold the land in 2010.
2000,
Acquisition was 2017.
2015-16.
Then how will you get the money?
But therefore, my lord, my contention is that I only sold 10 acres. Remaining 22 acres are with me. But by forging the sale deeds, the claimant number 3 has claimed the land. Now the inquiry was conducted. Now inquiry finding is very clear that claimant number 3 is not the owner of the land. She did not entitle compensation. So these are the merits of the report. So if otherwise, well, we are ready for.
But how is this a public interest litigation?
Well,
How is this a public interest litigation?
No,
but with regard to, my lord, the expansion of the airport, segregated.
Initially, my lord, it was only for the expansion of the airport. And this was registered separate, subsequently as a separate Miss PIL on the direction of His Lordship, because we don't want to mix, because this issue is only on the direction given, request given by the Honorable Supreme Court to the Chief Justice.
Let us see the order.
The order, my lord, this second, may I just read, my lord, 2nd August 2017, my lord, order of the Supreme Court. My lord, all the orders who have been placed before the records, my lord. Court Masters, 2nd August 2017 order. Of the Supreme Court.
Supreme Court order.
We don't have it. It's not in the reports.
This.
My lord, the Supreme Court order is available in my, in fact, affidavit we filed. Yep.
In the orderly. The district judge has furnished his report.
Yes, my lord. First report was furnished on. Just give me a second.
What was that? That's right.
Focus. Yes.
कैसे खुल गया कैसे? Yes.
The first report was submitted on 24/11/2017, my lord. Now, we will not go into the first report, and my lord, I'll just draw my lord's attention to order dated 21st February 2023 of this court's order, my
We
lord.
have seen the
Yes.
second report has also come.
Yes, yes. Now the second report is here, my lord. So we have to take a judicial note on the second report, my
What
lord.
does the second report say?
The second report says, my lord, in fact, there is 9,64,48,258 is an excess amount that was received by the claimant number 3, respondent number 3, the claimant number 2, Patricia Nongsage, my lord.
She was the tenant.
No, she was the lady who said, I bought the land from claimant number 1, the client of senior counsel, Mr. Sangreso. So she was the one. So now the claimant number 1, the client of Mr. Sangreso.
But prior to buying, she was the tenant.
No, she was not a
was not a
tenant.
tenant.
The people who moved before the Honorable Supreme Court are nowhere. Here in this proceeding are nowhere. They went to the Supreme Court saying that we are the tenant. And
We want a share of the compensation.
yes, but they got nothing. And even this Honorable Court gave them the opportunity, if you have anything to say, go before the district judge. They never came forward.
And another part of the PIL is extension.
Yes, my lord. That is separately is coming,
It is
my lord.
segregated. But the reason why this is still considered as a PIL is because the public money is still involved, whether the public money is squandered or not. Because of that, it is renumbered as a miscase PIL. But since the Lordship, the report is already here, my Lord, matter may be fixed for a hearing. Today, my esteemed colleague is seeking for some adjournment accommodation. Matter. Otherwise, we already made this pending for quite some time.
Second report objections have been taken
Objections have come, my lord. Yes, my
You have
lord.
taken
All the parties has filed objection
Objection, my
to
lord.
the second report
to
also.
the second report also.
Yes, my lord.
Pleadings are completed. Madam.
Whether excess funds have been taken or not. By the seller from the buyer. How do you decide in public investigation? The evidence has to be taken. So we can keep this part pending, the expansion of the runway, and as far as the other part is concerned, we take steps in a civil form. Yes, yes. That money should be set up. Who is holding that money, excess amount? Where is the excess amount?
My lord,
You are the seller.
I'm the seller, madam. The claimant number 2, Patricia Nonsi, she is the recipient of that compensation.
How much total?
Total, my lord, out of the 32 lakhs, she has received 25 crores.
25 crores.
Out of 32 crores, she has received 25 crores something.
24 crores, 70
And the
lakhs.
remaining 20% are still with the collector. Collector is yet to release the 20%.
I'm not able to identify because there was one order passed by this court, my lord, to keep the amount on lien, the bank accounts of them. I'm not able to find out the order, my lord. I will pass on later on, my lord. There was one order I remember, my lord.
Excess of 9 crores.
Excess of 9 crore, but that is a finding of the.
My lord, in fact, there is no specific finding rendered by the district judge. But district judge rendered a finding that the compensation awarded to the recipient appears to be exorbitant. But the exact amount is not identified by the
How do you get 9
district
crores?
judge.
My lord, this amount I came out of the report of submitted by the magistrate. By calculating, my lord, this amount was worked out, my lord. This amount which I have just submitted, just apprised to my lords, are the workout from the reports calculated by the district judge, my lord.
Total consideration paid?
My lord, it's a total consideration paid is 25 crores 70 lakhs 80,258.
That is 80%.
Yes, my lord, that is 80%, my lord.
That balance 20% is payable.
Payable
For the
my
state.
State. My lord, here the collector was,
Balance, this 20% is payable.
Yes, madam. The 20% has not been released till now.
But it is to be paid. There is no dispute about it.
Yes.
It is not here. Okay, it's body. It is body. Send copy. No body. Send copy. We get explaining.
It will be determined by the civil court, then we can bring it back and see what can be done to the collector. If it has to, it is in the sense of the district. Additionally, it appears to be right. It will be. Yes, please take down. We have heard the parties at length. Next, this public interest litigation concerns an inquiry into excess compensation, if any, paid to the owner of the land on land acquisition for the purpose of extension of the Umrah Airport. This public interest litigation was started at the request of the Supreme Court to the Chief Justice of this court, by its order dated 2nd August 2017, to start such an inquiry. An inquiry was duly started, stopped. Paragraph. The district judge, what? Liboy. Yes, District Judge Liboy's district was directed by this court to conduct the inquiry. Full stop. Orders were passed in this writ application from time to time by this court, monitoring such inquiry. Full stop. Next, initially, a report was filed. Full stop. Subsequently, a second report was invited and filed by the said district judge. Full stop. Next, all the necessary parties, namely the owner of the land. What is her name, owner of the land?
Patricia.
State the car, man.
State Dakar.
State the car. Srimati State the car.
A part ownership is also with my client. Maxila. 10 acres.
Yes, your name?
Maxila.
You got the name? The owners, comma, the purchaser. What is your name?
Patricia.
Patricia Nongsich.
Comma. You are the writ petitioner.
My lord, I have been appointed as an amicus, my lord, in
Yes.
this matter.
The amicus curiae, comma. Amicus curiae appointed by this court, comma. Learned counsel for the central government. Learned Deputy Solicitor General
For Airports Authority.
for the Airports Authority. And learned counsel for the state. Yes, okay. We have heard her. Very well. It appears from the second report of the learned district judge that about that, not about, rupees 25,70,80, 258. It's sum of rupees so much, no? Representing 80% of the compensation has been received by the owners. Full stop. There is no dispute that the owner in due course would receive the balance 20%. Full stop. Further, according to the said report, a sum of about rupees 9 crores has been received by the owners, in excess of the market value. Paragraph. By the tenor of the said Supreme Court order, the scope of this public interest litigation has been widened not only to make an inquiry into the excess sum paid alleged excess sum paid, but also to fix responsibility and take action against the land officials responsible for such an illegal act. The highest court directed us to decide the matter on the judicial side. Paragraph. Now this report of the learned district judge that rupees 9 crores have been paid in excess to the owners can best be described as an expert's opinion on the available evidence or a piece of evidence which should be subject to proof and adjudication of the exact excess amount paid, if any, in a civil jurisdiction. To come to a final conclusion only on the basis of the report of the learned district judge without giving an opportunity to the affected parties or the beneficiaries of the report to disprove those findings or to establish those findings, in a proper proceeding, would not be a judicious act. Paragraph. In those circumstances, the person making an inquiry is the district judge of the area.
Yes.
Yes, my lord. No, poor my lord.
Well,
My lord,
she's
may-
the special judicial officer in the Land Acquisition Act. In view of that, my Honorable Supreme Court referred the matter to. She has even the power to decide the question of disputed facts, ownership entitlement. Therefore, she rendered a finding that the claimant number 1 and 2 entitled, 1 and 3 entitled, claimant number 3 is not entitled for compensation also.
this report, my lord, this
This
report,
district judge's court is also the civil court to decide this subject matter.
yes, yes,
Under
yes,
the
my
Land
lord,
Acquisition
yes.
Act, my Lord. She
Under
has the
the,
power. She is a reference court, my Lord.
yes, my lord.
In view of that, my Lord, the Supreme Court referred the matter to the district judge.
And this report, my lord, this report has been submitted only after all the parties were given enough opportunity, cross-examination, depositions, cross-examination, then only this finding has come, my lord.
Yes.
Claim and
Claim petition
counterclaim.
files,
all those,
counterclaim
my lord.
file.
That is also done at the time of determination of mean profits in a tenancy matter, done by the commissioner or done by the special referee. But it is subject to affirmation by the court.
Court, my lord,
It's the
that
same
is,
court.
that's, yes.
This is the same court where the reference on the quantum of land acquisition goes, my lord.
No, but when the learned district judge has been the referee, then it should be assigned to some other district court.
Because ultimately civil dispute goes, my lord, it will go to the same court.
It goes to the same court, but there is any other judge competent to hear it.
Additional district judge.
Hearing was thorough. Inquiry was done in presence of all the parties.
Can be referred to the in that district.
Grade 2 judicial officers are there, my lord.
Yes.
Chief judicial magistrate is there.
No, he doesn't have the jurisdiction.
The senior civil judge is there.
Civil power.
But, my lord, the findings of the higher court, my lord, will be subject to scrutinize by the subordinate court.
But with great respect, my Lord, the learned district judge had exercised the civil court.
No,
Read with the land acquisition and
my lord, district
came
judge
to
is
a finding.
conducted as an inquiry officer, not as a district judge.
Yes.
Under administrative order from the school.
Some inquiry under section 18 of the
1830
18.
and 30 also apportionment.
18. Well, if I may submit a little mirror, here mirror the jurisdiction exercised by the Honorable District Judge is as good as exercising powers under section 18 and section 30 of the old Land Acquisition Act, 1894 Act. Because so to that extent, it appears that the requirements of the Land Acquisition Act of a reference court that has been complied with.
He has not exercised powers of a court. He has exercised powers of an administratively
Inquiry
under
officer.
order of the Supreme Court.
No, that is where I am submitting. Milord. My submission here is Milord, because
We will transfer this matter to the district and session judge Shillong.
Shillong.
Yes.
Yes,
Who
my
will
lord.
treat this as a reference and decide the matter.
Yes,
accordingly.
yes, my lord. Yes.
Right? District and session judge Shillong is.
So district and sessions are also the special judge under the Land Acquisition Act.
Yes. In those circumstances,
64.
Old Act. Let's go under Old Act.
we request the learned district judge to transmit this case to the learned district and sessions judge, who is also
Special Judicial Officer, Land Acquisition Act.
special judicial officer under the Land Acquisition Act. District and sessions judge Shillong.
64.
Authority.
Authority, yes. Authority.
Who would treat?
Under the new act.
Who shall treat the same as a reference and decide the matter. Following due procedure. Upon taking necessary evidence and hearing the parties, and by a reasoned decision within 2 months of communication of this order. Full stop. The decision of the learned judge shall be duly transmitted to this court by the registrar of the district court for us to deal with the matter in accordance with the said judgment of the Supreme Court.
My lord, what happens to this report of the district judge, my lord? This report, which is before my lord, what happens to this report now? I mean, so what will be the fate of this report? Because will the authority?
You arrange a seminar, I will tell you what happens to the report.
Absolutely.
I will tell you. I will give you a lecture on what happens to the report and what will be the effect. But in a judicial capacity, I cannot give a lecture on that.
No, my lord, I was just inquiring because.
No, yes. No, the 20% will remain. The state will not.
25 crores is with her. 50% is with her.
There's already an order.
That's right. What is the
This order is there, restraining you from parting with the money.
Yes,
There-
yes.
there-
The previous
there-
orders are there. Orders.
My lord, in fact, there are several orders. In one of the orders, my lord, there is an affidavit taken from the person who received the compensation, because it was placed before lordship that she has purchased alternative land by that money. So those land documents were deposited before the registrar. So the amount has been secured, my lord, otherwise. And 20% is still with the government.
Yes, all subsisting interim orders in this public interest litigation will continue.
Yes.
And the state shall not disburse the balance 20% to the balance 20% of the compensation to the owners without the leave of this court. We make this application returnable on
That's right.
24th June.
Lordship, I have a small prayer, Lordship.
Yes.
This report may kindly be furnished to the state, Lordship. Because we don't have the copy, Your Lordship.
Which report?
The report submitted by the Learned District Judge, Your Lordship.
Yes, will be transmitted to this court. Copies thereof will be circulated to all the parties.
Highly advised.
I have a small submission, my lord. Though it is, because 2 months granted for the Learned District Judge Shillong, my lord, may be too heavy for the court. Because Learned District Judge also discharging a CBI court, my lord, NDPS court and so many. So the lordship kindly considers to grant a little more time, maybe 3 or 4 months time.
3 months, then, Your Lordship.
Because court is very,
In any case, we are keeping it in June. 3 months.
Lordship, yes. All right.
My lord.
You see that report, I am telling you now, that report of the learned district judge in his administrative capacity as an inquiry officer
My lord.
or as a special referee
My lord.
will be treated as a piece of evidence. That's all.
My lord. My lord. I was
Like an expert, like a handwriting expert's
My
view that this is the handwriting or this is not the handwriting. That is subject to proof by import. That's all.
My lord, I got obliged, Lordship.
Because just on the basis of the report,
Yes, my lord.
if we take action against the district collector
Yes.
or we appropriate that money from the owner,
Yes.
I don't think it will be a very judicious decision.
My lord. My lord.
It should be subject to strict proof.
Yes, my lord.
Item number 4.
Obliged.
Yes.
Because these appeals were last listed on the 10th of February. At that time, we had prayed that we may be permitted to file an affidavit to file some additional documents. Lordships had directed us to file an application under Order 41, Rule 27. We have filed that, my lords. It is before Lordships today for consideration.
But I've received the application, my lord, permits me to obtain
You want to
instruction.
file affidavits?
But I'll obtain instruction, my lord. If the department has any objection to these documents or not, my lord, on next date I'll apprise your lordship. And if you file, we'll file before the next date, my lord. So these documents were not there before the learned single judge, my lord.
Order 41, Rule 27?
Lordship.
All right. This is an application under Order 41, Rule 27 of the Code of Civil Procedure. Learned Deputy Solicitor General, for the respondents, seeks time to take instructions. List this application on 18th March, full stop. In the meantime, if the respondents so desire, an affidavit in opposition may be filed by 10th March, full stop. In that event, affidavit in reply may be filed by the returnable date.
Obliged.
Item number 5.
I can move for how many matters are there? 4. One MC. Yes.
But this is the matter, my lord. We have come against the order passed by Central Administrative Tribunal. The matter concerns payment of reimbursement of medical allowance, my lord, post retirement of the employee, of the respondent, my lord. But here what happened, my lord, the respondent was serving in.
They taken dialysis throughout
Yes,
the day
yes,
in
madam.
an OPD.
Yes, this is the matter, my lord. By interim order, your lordship is directed for securing 15 lakh rupees, my lord, in a fixed deposit. We have done that, my lord. So that money has been kept apart, my lord, subject to the outcome of this matter.
What is the claim?
Now to
It's a recurring claim, my lord.
11,90,000 I have already submitted.
But the hospitalization claim is allowed.
It is allowed. It is allowed.
Population claim is allowed
Allowed.
on the condition that he does not claim fixed medical allowance on monthly basis, my lord. Because he was claiming fixed monthly allowance, my lord, of 1,000 rupees.
For
per month.
hospitalization case, nothing is required. No bar is there, my lord. It is allowed reimbursement.
No, because he's taking monthly, then what is not allowed?
This OPD,
I'll just-
outdoor
My lord,
expenses.
my lord, there are two schemes, my lord, in the ICA. If somebody is claiming fixed monthly allowance, my lord, of rupees 1,000, then he will not be entitled to outpatient claims, my lord. Outpatient means daily visit to doctor, my lord, whatever medicines are prescribed. Because it is presumed, my lord, that 1,000 rupees per month will cover that part. But inpatient, if there is a hospitalization case, they are still allowed, my lord. Now here what happened, my lord, the respondent claimed fixed monthly allowance. So he was not entitled to OPD bills, my lord. But he claimed OPD bills. IPD, there is no dispute, my lord. Inpatient, if the patient is admitted in hospital, all bills are reimbursable, my lord, as per the rules. There is no dispute with regard to that. And the rules also provide, my lord, if a retired employee in his lifetime can switch over from one scheme to other. So our case is, my lord, if he is not happy, he is not satisfied with fixed monthly scheme, my lord, he should write a letter, write an application. We will switch it over, and the future claim, even for OPD, they'll be entitled to, my lord. But they cannot have both, my lord. On the one hand, they'll take fixed monthly allowance also and also claim OPD bills, my lord.
How much time was taken for dialysis every day?
6 hours.
Which hospital?
Bethany Hospital, Shillong.
Government hospital.
No, not CGH hospital. It was approved by the director. Special approval was given. Just take page 60, my lord, I refer. Only few pages I will refer. Then page 60, my lord.
You took it in one hospital only?
Yes, only one hospital, as per approval for dialysis.
If we do this, Mr. Mozarika,
My lord.
that as far as the previous dialysis is concerned, 6 hours he has spent. So we will direct the hospital to declare that as being hospitalized for the day, for that period. And for the future, he will make an application to you to switch.
But future, as far as future is concerned, my lord, that is my instruction. I can agree to that, my lord. But only that part, my lord, will be a substance.
And
My lord, I have already given application. It is at page 11, my lord, in their affidavit. Just go through. Page 11 of the affidavit.
hospitalization, yes. Deputy is saying OPD like 1 minute visit.
And our main concern is, my lord, there are 110 centers of ICR all over the country, my lord.
Sorry?
Indian Council of Agricultural Research has 110 centers all over the country, my lord. Now, this should not be a precedent, my lord, because otherwise what will happen, my lord, they'll claim both, my lord. On one hand, they're claiming fixed monthly allowance also, and then again claiming OPD. IPD, there is no dispute, my lord. IPD, they are entitled to under the rules.
No, this dialysis will be taken as hospitalization, nothing else.
Only for this.
Yes, my lord, only that.
And this will not create a
We
precedent.
do not know the other procedures for dialysis.
My lord.
Some dialysis may be over in, nowadays I hear in half an hour it is over.
My lord.
Some technology.
My lord.
And as far as the dialysis he took, it consumed 6 hours every day.
My lord, there is, I don't really agree to that, my lord. It takes 6 hours in today's time, my lord. But
Not so
I
much
know, my
time.
lord, it takes much less time, my lord.
My lord,
But it should not be taken as OPD. One has to lie in bed and get it done. The whole blood has to come out, has to be drained out, and fresh blood infused. Right or wrong?
My lord, my only concern, my lord, if a general order is passed that all dialysis cases should be taken as IPD.
No, in that particular hospital, the particular patient, that's all.
my lord, I have already. Can you
You are
see?
getting the order, what else you want? What you are saying?
I have already submitted application, one-time application, whatever they have said. Page 11, my lords. Can you see?
What is the harm in submitting a proper application?
Page 11 of their reply. 29/10/2024. is only confusing, my lord, everything. So just give me 2 minutes time, I will explain.
You are getting the order, why you want 2 minutes time? For what? To reverse that order?
No, my lord, I have already applied. I have already surrendered.
All right, you will get from future. We are giving you in the past, you don't want it. You don't want the past. You have applied, you will get.
Okay, Master.
Where is that? Where is the application? This is a affidavit. It shows the application.
Application is at page 89, my lord. Read petition.
So where have you stated you have undergone dialysis and all that?
That is at page 60, my lord. Page 60 of the read petition.
Bethany Hospital?
Yes, yes, my lord.
Where are the bills?
Bills to I have submitted, my lord, at page 89. At page 66, my lord.
So,
66. Reimbursement was refused. Page, para 2. You are informed that extant medical policies of ICR does not allow the reimbursement of OPT bills in cases where the pensioners is availing fixed medical allowances. The institute has processed your case as per rules and guidelines on the subject. by this letter, reimbursement was denied. Now, my lord, I refer page 11 of the affidavit, rejoinder, only one page. Page 11 of their reply, dated 29/10/24. Page 11.
Yes.
ICM medical policy for the pensioners also allow one-time option for pensioners to withdraw the fixed medical allowances and claim their medical reimbursement as an outpatient as per CSMA rules, which the respondent is aware. Once such withdrawal is made by the respondent, his medical bill claims for treatment as outpatient can easily be reimbursed by the institute.
All right.
My lord, here importantly, rule position indicated by them that if I give the option, willingness for withdrawal of the fixed medical allowances, then my OPD bill can be reimbursed. I have already given application in 2012 at page 89, 21, 12, 20. That was not considered, that was not
All right. Please.
pending. And CAT also.
They don't want relief.
The writ petitioner's wife. Is suffering from kidney failure. Full stop. The petitioner, being a state government employee,
Yes, central government.
central government employee, comma, after taking approval of the competent authority, ICAR Research Complex for NEH region, Uniam, got hemodialysis done at Bethany Hospital, Shillong. Full stop. Such procedure was carried out at the OPD, that is outpatients department,
Outpatient.
at the outpatients department bracket OPD of the hospital. Paragraph. Under the medical policy of ICAR availed of by the petitioner, which granted fixed medical allowance bracket FMA he was not allowed reimbursement of OPD bills. Paragraph. This was pointed out to him by a letter dated 20 October 2022 by the Under Secretary of Krishi Anusadhan Bhavan, Roman 2, Indian Council of Agricultural Research, New Delhi. Paragraph. The pending bills for dialysis as on that day and even subsequently have not been paid on that ground. Where is that letter you have written?
Page 66.
No, your letter.
My letter is at 89.
Paragraph. Much earlier, on 21st December 2020, the petitioner had written to the authorities in New Delhi to extend him facilities of cashless medical treatment under CGHS and in the interim period till the facility was granted, fixed medical allowances may be withdrawn and medical expenditure reimbursement facility for both indoor treatment and outdoor treatment from any recognized center may be extended to him. In fact, in the affidavit in opposition filed by the central government, they have said that this switchover is possible. Paragraph. We have taken note of the submissions of learned counsel for the petitioner that the dialysis process, although carried out at the OPD of the hospital, consumed at least 6 hours.
4 to 6 hours, my lord.
4 to 6 hours. Every day. Most of the patient had to lie in bed and undergo the procedure. Paragraph. As far as the pending bills of the petitioner are concerned, No, you strike that out. We direct Bithani Hospital, Shillong to treat the hemodialysis process being undergone by the petitioner's wife as one undergone after hospitalization. Comma. Correct their records accordingly and issue a certificate to that effect to the petitioner and or his wife within 2 weeks from communication of this order. On the basis of the above, the hospital will issue revised bills You have paid those bills,
Yes, I have paid.
showing them as paid. Full stop. The petitioner will be at liberty to present those bills to the respondents to seek reimbursement. Paragraph. Furthermore, the respondents your letter page 60,
Which one, my lord?
your 2020 letter,
2020 letter is at page,
just now you have said,
yes, this is the 89.
will process the application made by letter dated 21st December 2020 at page 89. Of the writ petition. What have I said? Will?
Furthermore, Thomas responding will process the application with
And allow the petitioner to withdraw from the scheme providing fixed medical allowances and avail of the one where medical expenditure reimbursement facility for both indoor treatment and outdoor treatment as per CS within bracket MA rules. Full stop. Such decision, such conversion should be made within 4 weeks of communication of this order. This writ application is accordingly disposed of.
And my lord, this my bill should be processed. Already I have submitted. 11 lakh on 5/8/24, page 70, my lord. I have surrendered these fixed medical allowances 44,000, and that order I have given, and bill also I have given 11 lakh.
It is liable to be rejected because it is OPD bill. You have not heard what the order said. That they will issue a fresh bill saying that it is hospital bill. Then they will pass it.
My lord, a small observation, my lord.
Yes.
That this will not create a precedent, my lord. This order will not create.
No. This kind of an order, illegal orders are couched in that way. Not create a precedent. Why are we scared to pass an order? 6 hours, we are saying it's hospitalization. Mr. Mazarika, there is no fear, there is no embarrassment. You go to the Supreme Court, prefer an appeal, and test this order out. But we will not say create a precedent as if hiding and passing an order. Yes. Take this order, but don't come for further orders.
No, my lord, why I am saying, my lord? Because he availed both, my lord.
No, they will. If it is like this, all will get. If it is 6 hours dialysis lying in bed, and it will not be taken as OPD.
My lord, that was on his verbal submission. I do not know.
Anyway, if I am wrong, please go to the Supreme Court.
My lord, I'm not submitting that, my lord.
But we feel, my brother also feels 6 hours dialysis is hospitalization. And you cannot be so narrow in your thinking as to shut his medical benefit on that.
My lord, we are not. My lord, we are not. If he has not claimed a fixed medical allowance, my lord, he is entitled to. I am submitting today also, my lord. But he is wanting both, my lord. But that is where
He
the
is
problem.
not wanting both, he is wanting conversion. And we've said we will allow conversion. And as far as that is concerned, he will get it. And we will also add a line that after payment of the dialysis bills, no, at the time of payment of the dialysis bills, all monthly payments made to the petitioner shall be deducted.
Well,
Finished?
Deeply.
My lord, the petitioner should be replaced by its respondent. Somewhere petitioner has written. So,
We will check it out.
okay, much obliged.
Yes.
Item number 6 to 16.
This is your lordship.
Yes.
Lordship, this is a state appeal, your lordship. It's against the common judgment, your lordship. This matter can be taken up on some other day, your lordship, now.
Sorry?
Taken up on some other day, your lordship. Not today.
Tuesday?
Yes.
Tuesday.
Yes.
I'm sorry, your lordship. I could not get your lordship.
Tuesday. There is some problem with the audibility. It is not coming clearly.
Tuesday is what day?
Maybe Wednesday, my lord.
Tuesday.
You check up the sound system also. It is not audible. It is like a garbled voice is coming.
Will do.
Wednesday. No, my lord, can it be made on Wednesday, because on Tuesday I got some problem. Tuesday is okay.
No, Tuesday is 4.
Oh. Okay. What is okay?
Tuesday is 4th.
Your lordship will do. Yes.
Up to 16.
Yes, your lordship. Against the
Okay.
common judgment.
By consent of learned counsel for the parties, hearing of these appeals and connected applications is adjourned till 4th March.
4 March, lordship. I'll apply, your lordship.